Well, it's a risk a lot of Idaho's OBGYNs and maternal fetal medicine doctors say they face every day with their pregnant patients. That was just a sample of the nearly 2-hour oral arguments from April. The Supreme Court is expected to rule on the state's abortion ban as it relates to EMTALA before the end of this month, and it could be as early as tomorrow, which is why today we are taking a look back at the impact of those abortion bans in the 2 years since the Dobbs decision, beginning with the bill that seemed to be created in a vacuum until it wasn't anymore, and the unintended or maybe intended consequences since abortion became criminalized in Idaho. On one of the waning days of the 2020 legislative session,
the House will be in order.
About 4 hours and 15 minutes into a 7-hour agenda.
Good lady from District 23.
Thank you, Mr. Speaker.
House Majority Leader, Representative Megan Blanksma, brought Senate Bill 1385 to the House floor.
Under this new section, those performing criminal abortion will be charged with a felony punishable by no less than 2 years and no more than 5 years in prison.
It would become known as Idaho's abortion trigger law, criminalizing the procedure should the Supreme Court or an amendment to the U.S. Constitution restore such authority to the states. Was there an idea of like, well, this will never happen anyway?
I think that was everyone's expectation of Roe in general, right? Is that nothing was ever going to change.
Should it change, Idaho's abortion ban would only allow a couple of exceptions.
1, the abortion was medically necessary to prevent the death of the woman. Or 2, the woman has reported the act as rape or incest that resulted in the pregnancy to a law enforcement agency.
Those opposed to the bill noticed one exception was excluded.
Can you highlight where within the text of the bill it stipulates the health of the woman?
Representative Blanksma couldn't.
Lady from 23.
Thank you, Mr. Speaker.
Because it didn't exist.
Shall Senate Bill 1385 pass?
Still, Senate Bill 1385, Idaho's trigger law.
The vote count shows 49 in favor with 18 against and 3 absent. Senate Bill 1385 has passed the House and we return to the Senate.
Was signed into existence by Governor Brad Little 6 days later.
Here's the scene right now of crowds.
Jump ahead to June 24th, 2022, when the expectation of nothing was ever going to change
The joy that it was finally overturned
did with the Dobbs decision.
Right now, new laws banning abortion are taking effect in several states.
2 months later, on August 25th, after sorting out a couple of early court challenges, Idaho had an abortion ban on the books. However, the law's legal problems were far from over. Just before Idaho's ban was triggered,
today
the U.S. Justice Department filed its own lawsuit against the state, claiming the law violated the Federal Emergency Medical Treatment and Labor Act, or EMTALA.
If a patient comes into the emergency room with a medical emergency, jeopardizing the patient's life or health, the hospital must provide the treatment necessary to stabilize that patient. This includes abortion when that is the necessary treatment.
With that filing, a federal judge granted a preliminary injunction, meaning the law could not be enforced while the lawsuit went through the courts. Several appeals courts lifted that injunction, then reinstated it. And then finally, it was lifted again by the highest court in the land when they agreed to hear the case. A legal back and forth that for Idaho's doctors wasn't nearly as difficult to discern as the law itself.
Fetal anomalies don't know any bounds. They don't discriminate against anybody.
Dr. Duncan Harmon works at St. Luke's, and he's one of 5 maternal fetal medicine specialists left in Idaho.
We focus mainly on high-risk pregnancies, which is kind of a loose term, but women with pre-existing or pregnancy-related medical conditions, whether that's somebody with pre-existing diabetes, high blood pressure, they develop preeclampsia,
or they have some sort of autoimmune disease. MFMs are also called on to care for fetuses with anomalies, which are more common than you might think.
Roughly 3% of all pregnancies are affected with some sort of congenital anomaly, and those kind of get filtered into us in our world.
Dr. Harmon says that preventing the death of the mother exception for abortion puts him into an inverse relationship with his patients.
The more close to death someone becomes, the less liability I have of either going to jail, facing a criminal lawsuit, or losing my medical license because that patient was on death's door.
You don't want to get to that.
Yeah, I mean, my Hippocratic Oath is to do no harm. I'm not going to sit and wait and watch somebody to become sicker so that I become less liable. I want to act in the best interest of the patient. And so many of those circumstances involve me transferring a patient out of state so they can receive appropriate medical care before deterioration occurs.
EMTALA, Dr. Harmon says, offers some sort of Band-Aid for emergency room doctors, but within a limited time frame.
What about the patient who's not on death's door, but is developing or is headed down the route of developing complications that will ultimately lead to end organ damage or need for transfusion or an ICU admission or a need for dialysis or a need for a hysterectomy and lose their potential fertility in the future? We want to prevent even that from occurring. And so that's where the decision making for us is a bit of a conundrum. And the law says we can provide treatment and abortion if it's necessary to prevent their death. But we're 9 or 10 steps before that potential end outcome. And EMTALA is a small portion of what may help us treat patients appropriately because it's a small window of time, but the bigger and more important change is a health exception.
Several doctors wish that specific concern was considered more closely 4 years ago.
I think knowing what we know now, if we would have just tweaked it a little bit better on the initial move.
That's not all Representative Blanksma would admit about her role in establishing Idaho's abortion ban. How did that come to be?
I was the only woman in leadership, and I was assigned the bill.
You were assigned the bill?
I was assigned the bill. Are we taping right now? Because I just...
Yeah.
Right now. Okay. Yeah.
Blanksma says it's not uncommon for important legislation to land in the hands of leadership, but this decision was more about image than influence.
And so one of the discussions was have Megan carry it.
Because you're a woman.
There's a lot to be said for how things look when you're presenting a certain type of legislation. And I think that would, the optics are just not good when certain members are presenting.
Did it give you pause a second, though, to consider why you were chosen?
Not at the time. I think there was an expectation that I would be asked to do it. And I could have said no, but it was you're on the team, so you're working for the team.
Okay, not at the time. Now, in hindsight, how do you feel about that?
In hindsight, I wish we'd had some more information because obviously there's some glitches in it.
How so?
Well, I think that we're looking at, there's so many complications that can happen with a pregnancy, and I think that to put it in black and white is a very difficult job. But I think there were some exceptions that just didn't come up at the time.
What we've heard is it would be a simple solution and changing it from life of the mother to health of the mother.
And see, that's not so simple to move on the House floor because that's when we get to the sliding scale. I understand what they're trying to say, but it then becomes a very broad definition. And then that's when people start to get nervous about changing the existing law because they don't want doctors to make an excuse to start performing elective abortions. That's the fear with that language.
Representative Blanksma did try to make clear some of that language.
This is a cleanup of the trigger law that many of us remember well.
In 2023.
We're making sure that there are no unintended consequences related to the law.
House Bill 342 would remove the affirmative defense for the doctor, but that's not all.
And then the addition on page 3, line 18, or to treat a physical condition of the woman that if left untreated would be life-threatening.
The bill...
Is there discussion on that motion? Seeing none, all in favor signify by saying aye.
Aye.
Opposed, nay. The motion is carried. It will be done.
Never got a hearing. But about a week later...
These 3 things that it adds are the removal of a dead unborn child.
House Bill 374 did.
Well, the purpose of the legislation is to provide additional clarity, and that's part of why that language was taken out, is because we couldn't provide enough clarity to feel comfortable with what it was.
The language taken out? The part about a condition that left untreated would be life-threatening.
We want to make sure that health of the mother doesn't become so broad that everything becomes an exception to take the life of a potential child, because unfortunately there are some who take that position.
374.
Motion passes 11-2.
Pass committee.
Question is, shall House Bill 374 pass the House?
It then passed the House that afternoon.
59 ayes, 1 nay, 10 absent and excused.
And it passed the Senate the next day.
The roll call shows 26 in favor with 7 against and 2 absent.
But it wouldn't be enough to pass muster with Idaho's maternal fetal doctors.
Just to allow patients some sense of grace in a situation of which they didn't choose to be in.
Dr. Harmon says a big part of his job is counseling patients on their options when it comes to managing pregnancy complications or fetal diagnoses. Those discussions, he says, now include a third party.
The third party in the room is the decisions that have made outside of this room that impact what you can and can't do in the state.
And so when you counsel them through this decision, how many times have you had this counseling and actually had somebody say, I need to go elsewhere then?
I mean, tons of times.
Really?
Yeah, I mean, but these aren't stories that come up in the media because these are very private moments that are devastating to families who have a very desired pregnancy, and it's heartbreaking to them.
We've created some unintended consequences. I think that there are those of us who believe that the docs are covered, but when the doc doesn't believe they're covered, that's where you have the problem, right?
Will it change? Will there be a change, you think?
I don't know. It's just going to take a negotiation, and just the blanket health of the mother it won't move, I don't think, in the next legislature for sure. It has too many consequences, one way or another.